Thank you, Your Honor. At the outset, I want to state that the state does not condone or defend some of the notes displayed by the defense in their earlier presentation. But it is worth noting, I don't believe the defendants asserted any of those were from his trial. And nothing so far has been presented about the events of February 16th when Anthony Searles was murdered. Claims by a defendant, even claims of racial discrimination, cannot be presumed upon mere assertion. They have to be proven by preponderance of the evidence in open court. After the hearing this court has conducted, it is clear the defendant has not proven his claims of discrimination. As defense showed this court earlier, the purpose of the North Carolina Racial Justice Act is illustrated in 15A 2010. No person shall be subject to or given a sentence of death or shall be executed pursuant to any judgment that was sought or obtained on the basis of race. The text makes clear that the thing to be examined is a judgment, a specific judgment, and whether that singular judgment was sought or obtained on the basis of race. The operative word sought or obtained requires some action that must be proven in court. In other words, the state argues again today, as has consistently, that defendant Bacote must show discrimination in his case for relief under the Racial Justice Act, must show by preponderance of the evidence that his individual sentence of death was sought or obtained on the basis of race. Now, you just heard the defendant ask you that no such showing is required, that he does not need to show any discrimination in his own case. But under that interpretation of the statute, in a case where a defendant was convicted in a capital trial where the state does not exercise a single peremptory strike, that defendant could be entitled to relief based solely on statistics of peremptory strikes in other cases. That cannot be right. That is a logical result that could not be the intent of the legislature when they enacted the RJA. It can't be that defendants who actually suffer discrimination and defendants who suffer no discrimination are treated the same. Oops, there we go. Now, not solely limited to these areas, there are three specific areas under the original RJA here that is shown under 15A 2011B1, 2, and 3. Specific areas that evidence may be relevant and may be considered by the court. Death sentences were sought or imposed significantly more frequently upon persons of one race than upon persons of another race. Death sentences were sought or imposed significantly more frequently as punishment for capital offenses against persons of one race than as punishment of capital offenses against persons of another race. And 3, race was a significant factor in decisions to exercise peremptory challenges in jury selection. The language for the charging and sentencing, or sought and imposed, however it's referred to, evidence, is very significantly from the jury selection part of 2011B. The jury selection based claims, it focuses on decisions by the prosecution to exercise peremptory challenges. The charging and sentencing or sought and imposed claims do not focus on decisions. It's whether they're imposed, the death penalty is imposed significantly more frequently upon persons of one race, or imposed significantly more frequently for punishment for capital offenses for the victim of one race versus another race. Now, this court has already stated that the standard is a preponderance of the evidence that the defendant must show. This is a post-conviction motion for appropriate relief. As the court knows, there's 2 ways to bring an RJA claim. One is pretrial. This was brought after the defendant was convicted. Therefore, under the amended RJA and the original RJA, they direct that that claim is brought post-conviction under Article 89 of the general statutes, the MAR statutes. And then under those statutes, the defendant has the burden of proof and has the burden of showing by preponderance of the evidence every fact essential to support his claim. Now, what claims are there? Defendant has abandoned all what he termed charging claims under the RJA, abandoned all claims termed sentencing claims except those based on the evidence from his own case and evidence from Johnston County based on race of defendants, and has not abandoned any of his jury selection claims. What evidence has defendant offered at this hearing for this court? The MSU study, a flawed statistical report on capital jury selection by a lawyer who never picked a capital jury, is not a statistician, and has had other testimonial reports found to be unreliable. Testimony from two statistical experts to attempt to bolster the MSU study. One of those witnesses, Dr. Smith, also performed an analysis from the witness stand, by my count, less than 5 minutes, claiming discrimination in sentencing decisions in Johnston County. Testimony from experts on general matters that weren't really linked up to defendant's case or the issues before this court under the RJA. Historical evidence, and history is important, but defendant has been unable to link the history he presented to the facts of this case or the jury's decision in this case, and didn't, I think it's fair to say, did not even attempt to establish such a link between that history and the murder of Anthony Searles on 16 February 2009. Also presented evidence of peremptory strikes from other capital cases. Not analysis of the strikes, per se, in terms of doing what I know they said they did comparative jury analysis. I don't think that was presented to this court in the way that term is normally used, but they did present through the MSU study, would say that that was not really a full analysis of the strikes. None of this evidence entitles defendant to relief, and none of it meets his burden. What do we know about the MSU study from Dr. O'Brien's testimony? She admitted she was not a trial attorney, selected one non-capital jury trial in her career. She admitted she was not a statistician. She admitted she was not an expert in causal inference. She was offered and accepted by this court as an expert in social science research and empirical legal studies. She admitted that the MSU study could not determine if any single strike was race neutral or not race neutral. She admitted the MSU study made no account of any prior determinations by trial or appellate courts that a jury strike in a case was race neutral. She admitted that the MSU study did not code reasons for a juror being struck, but for characteristics from their list of variables. She admitted that in some other RJA MARs, based on the MSU study, those defendants argued that the death penalty discriminated against white defendants, and others argued that the death penalty discriminated against Native American defendants, all cited to the same study. She admitted the RJA statute was a factor in the design of the study, and she admitted that they received forgivable loans from the CDPL to fund the study, the Center for Taxing Litigation. And the first check in that regard was dated the same date as the effective date of the legislation. So that's what we know from Dr. O'Brien's testimony. What do we know about the MSU study from the Supreme Court? Well, as this court's aware, the Supreme Court held the MSU study is fundamentally flawed, lacked relevance, and has no probative value on the question of racial discrimination in jury selection. Why does the opinion in Tucker matter? In Tucker, the court stated, our precedent makes clear the test is and has been, talking about Batson, whether race is a significant factor in jury strikes. The RJA, the evidence that the defendant can show is race was a significant factor in decisions to exercise peremptory challenges during jury selection. Same question, same language. This is important for two reasons. One, it means Tucker controls here. Your Honor's already ruled on a preliminary motion that we filed pre-trial, but the state's position has not changed. We think Tucker controls in this case, and as a matter of law, the MSU study is without legal relevance. Okay, but even if this court does not apply Tucker to defendant's claims, it still clearly shows the fatal flaw of the MSU study. The MSU study ignores prior judicial rulings on racial discrimination and jury selection for cases that are in the study. In other words, it takes a peremptory strike that has been ruled race neutral and transforms it into alleged evidence of racial discrimination. The language is the same. Moreover, the Center for Death Penalty Litigation attorneys must think it's the same because under Batson and the RJA, because they used the MSU study to argue a Batson violation in Tucker and an RJA violation in Bacote. And Dr. O'Brien testified she looked at Batson cases to design the study. The test is the same. That's clear. Now, an illustration of that flaw can be shown from peremptory strikes included in the MSU study with the lead prosecutor, Your Honor, from State v. Bacote. Now, these are just 4 cases. As Mr. Ferguson pointed out, there are 4 other cases that were not included in the study because they were removed from death row or convictions, such as in State v. Richardson, happened after this, the end date this court established. Okay, in the 4 cases of the lead prosecutor from this case that are in the MSU study, a total of 29 prospective black jurors were peremptorily struck by the state. 17 of those strikes had Batson objections. All those Batson objections were considered by the court and denied. So even though over 50% of the strikes of prospective black jurors were deemed previously not to be discriminatory by North Carolina courts, these strikes are still in the MSU study as evidence of possible discrimination. Excuse me. That flaw is repeated for every single case in the MSU study where there are prior Batson rulings. This is important because the trial judge is in the best position to observe what's going on in jury selection and is the best arbiter of weighing if race was a significant factor. Now, in some of these rulings, like I say, there's some of the cases Mr. Ferguson mentioned. One of them was Richardson, which was tried by the same prosecutor as here. It went up in 2023. The North Carolina Supreme Court unanimously held there was no Batson violation, and cert was denied by the U.S. Supreme Court earlier this year. One of other courts held on Dr. O'Brien's credibility and reliability of her studies. Tucker, we talked about Superior Court, Supreme Court. A South Carolina court found her study was not relevant for causation in jury strikes. And then a jury selection study was held not to be reliable in a Wake County case in State v. Hill. As defense has gone through, other experts testified in support of the MSU study. Dr. Mitra admitted the MSU study was not a causal study, which isn't surprising because it's an observational study. Moreover, Dr. O'Brien said she couldn't tell if any single one strike was race neutral or not. So you can't show causation if you can't show a single strike was race neutral or not. But Dr. Mitra also testified that she couldn't say there were no unmeasured confounders. Dr. Smith testified in support of the MSU study, but he also admitted he didn't look at the underlying data, did not know if the coding was done correctly, and never set up a study like this before. What else did Dr. Mitra testify to? She said she wouldn't have adjusted for death penalty reservations. In her opinion, it was not appropriate to control for death penalty reservations in a study designed to analyze the relationship between race and peremptory strikes in capital cases. That's pretty incredible, and no other expert ventured that opinion. Mr. Ferguson just told the court earlier today that death penalty reservations was the highest variable for likelihood of being struck in the MSU study. But in her defense, Dr. Mitra readily admitted she had no idea what jury selection process is like and had never seen a jury selection. So, what is the value of the MSU study? Well, we argue to this court again, Tucker controls. If this court does not apply Tucker, we argue that because of the flaws that are also illustrated in Tucker, but we demonstrated in our cross-examination and the evidence presented by the defendant, quite frankly, that the MSU study is so flawed as to be meaningless. This court should not find it credible or reliable, and he has not shown, has not shown discrimination in jury selection in his case or statewide. What about his claim based on sentencing? As been discussed, Dr. Smith performed a new table from the stand. I don't know if the mistakes in the list of cases was quite as clear as counsel identified earlier, but there were some mistakes that were cleared up, I guess, by some of the parties here. And he did a table. He admitted he didn't look at any of the facts and circumstances of the cases in the sentencing analysis, victims, aggravating factors, mitigating factors, and they were just the numbers. There were no confounding variables, no regression. So it's clear that's a superficial report, but that's even not the reason why his testimony and defendant's presentation is so lacking. His analysis was completely irrelevant to the language of the RJA statutes. Going back to 15A 2011B1, the evidence there is death sentences were sought or imposed significantly more frequently upon persons of one race than persons of another race. B2, death sentences were sought or imposed significantly more frequently as punishment for capital offenses against persons of one race than as punishment of capital offenses against persons of another race. Dr. Smith's report did not address the proper question under the RJA. Defense counsel directed Dr. Smith to focus on far too narrow a data set. To determine whether death sentences were sought or imposed significantly more frequently upon persons of one race or another race, or as punishment for capital offenses against persons of one race and another race, you must look at the entire set of capital offenses, not just the very limited number of capital sentencing proceedings that take place. So what's a capital offense? A capital offense is one where the death penalty may be, but need not be imposed. That's not my definition. That's the North Carolina Supreme Court in more than one opinion. The defendant has presented no evidence whatsoever comparing death sentences for defendants of one race versus death sentences for defendants of another race that includes all capital offenses from Johnston County. Defendant has not presented any evidence similarly based on the race of the victims for all capital offenses in Johnston County. The sentencing analysis by Dr. Smith is completely irrelevant and meaningless to any claim under the RJA. Dr. Lee testified. And Dr. Lee testified that all analysis, including hers, the MSU, all analysis are subject to unmeasured confounding. None of the defendants offered reports on the clustering of data. None of the defendants offered reports that accounted for the clustering of data. And that she didn't think the MSU study provides sufficient evidence for a causal role. Now, why are confounding variables and clustering data important? Well, confounding variables, I think the court has a handle on, but I'm not going to waste time with that, except to say, like death penalty reservations, that's an important confounding variable that you want to control for, except for Dr. Meach's opinion, but no one else said that. That's an example of a confounding. Here, there are over 200 coded variables that were identified as observed confounder, I believe, by the MSU study. Far fewer were used in logistic regression models. And of course, the unadjusted don't account for any confounders at all. Clustered data means when data is grouped or clustered, you have to take that into account. Now, Dr. Mitra, Dr. Smith, and Dr. Bryant, I submit to the court, I believe the testimony is they acknowledged there was no accounting for clustering. In the MSU study, I believe Dr. O'Brien said she asked a statistician and was told it didn't need to. Dr. Smith said you didn't necessarily need to have it, but it was a common practice So I'm not saying they agreed with the criticism, but they acknowledged that it didn't exist, the accounting for clustering. And as for causation, well, Dr. Mitra testified she was not doing a causal analysis. Now, again, Dr. O'Brien admitted the MSU study couldn't determine if a single jury strike was neutral or not. So I don't know if that's really a dramatic reveal, but clearly, if Dr. O'Brien admits they can't tell if one strike is race neutral or not, that's not evidence that will meet the defendant's burden. There's some discussion about Dr. Summers, excuse me. Judge Summers, Dr. Summers. He testified as an expert in research, implicit racial bias, and effects of implicit bias. Now, I wasn't going to mention this, but they brought up his experimental jury study that had 200 study members, 90 undergraduate students, 81 law students, and 28 attorneys out of that 200. Dr. Summers admitted the p-value for the attorney section of that group was not statistically significant. Dr. Summers couldn't say if there were any prosecutors or criminal attorneys in those 28 attorneys. And the study was done out of state and wasn't in North Carolina. I don't think that study has any legal relevance to the issues before this court. But even turning away from that experimental study at Tufts University he conducted, Dr. Summers testified he was not a lawyer, he didn't review the transcripts of jury selection in the MSU study, and he didn't know how or if they coded variables that played a decision in reasons to strike. In fact, I was not in any way, shape, or form involved in that. Dr. Summers admitted he'd never been present during jury selection in North Carolina, had not even read the transcript in this case. And I think vitally, he testified that he could not say if any of the decision makers in this case had implicit bias. Not the prosecutors, not the jurors, no decision maker. He could not say if any of them had implicit bias. That's when the state moved to strike his testimony, and the court denied that, but I think that's worth pointing out, that he couldn't say that implicit bias touched any decision maker. Professor Stevenson testified as an expert in race and criminal law, race and capital punishment, race and jury selection. While Professor Stevenson offered testimony on history, legal history, and legal concepts, he didn't testify in detail about Defendant Bacote's case, other than the felony murder aspect of it, or any other capital case, really. Now, one of the defendant's exhibits, 273, was a report from Professor Stevenson's organization that noted the importance of representative juries. The Constitution requires the jury pool to be fairly representative of the community. In this case, defendant offered into evidence census data from 2010, a year after this trial took place. This particular excerpt is from page 151 of Defendant's Exhibit 365A, showing that in Johnston County, at the time, in 2010, the percent for white alone was 76%, 76.3%, and black or African American alone percent was 18.9%. Well, in this case, based on the jury questionnaires, there were 9 white jurors, 2 black jurors, 1 Asian juror. So 9 of 12, 75%. Census data for white alone was 76. 2 of 12 is 16.666 into infinity. And the census data was 18.9. So by the standards that Professor Stevenson's report advocates for, you could say this was fairly representative of the community. One other thing, there's been a lot of talk about Johnston County and history and culture, and can't connect, but there's been no connection. But I think one thing to this case, Your Honor, when I say that, I think one thing's worth noting is only 2 of the jurors, including alternates, were born in Johnston County. A lot of them were from out of state. The court can look at those exhibits. But only 2 are from Johnston County originally. Now, this court has already stated what the burden is for the defendant, preponderance of the evidence. It's defendant's burden to prove his claim. 15A1420C makes that clear, has the preponderance, has to show his claim by preponderance of the evidence of every fact essential. At this hearing, defendant Bacote has not shown any credible evidence that supports the finding by preponderance of evidence that sentence of death was sought or obtained on the basis of race. The statistical evidence doesn't support his claim. The MSU study is a matter of law without probative value to show discrimination in jury selection under Tucker. But even without the opinion in Tucker, the evidence this presented to this court clearly shows the MSU study is fundamentally flawed and meaningless. Again, the designer of the study, not a statistician, never tried a capital case, admitted in her testimony she couldn't tell if any jury strikes were race neutral or not. Dr. Smith testified about the MSU study. He didn't look at the underlying data, didn't know if the coding was done correctly, and never set up a study like that. Dr. Mitchell testified the MSU study was not a causal study, and also testified death penalty reservation should not be accounted for in a study on jury strikes and death cases. That's illogical. Clearly made by someone who hadn't participated in the criminal justice system and capital trial process. The sentencing analysis performed from the stand by Dr. Smith did not look at the set of cases required by the RJA and only looked at penalty phase proceedings. Not all capital offenses is required. Okay, so statistics don't meet this burden. What about other expert witnesses? Dr. Summers testified he couldn't say if any decision maker in the defendant's case was affected by implicit bias and hadn't read any of the transcripts of jury selection, including this case. Mr. Stevenson's testimony was largely unrelated to any facts of the defendant's case. It was more of a general review of the history of Batson and other legal cases. What about the defendant's own case? Well, the state used 6 peremptory strikes on prospective black jurors in this case. Every strike resulted in a Batson challenge. The Superior Court judge presiding over the trial ruled on every Batson objection and rejected every challenge. The state submits this court's bound by those rulings, that those strikes were race neutral. As for sentencing in this case, defendants presented no evidence that his sentence to death by the jury in his case was obtained on the basis of race. Simply put, defendant has failed to meet his burden of showing that his sentence was sought or obtained on the basis of race, with statistics or with evidence from his own case. Before I end, I want to address the historical evidence presented by the defendant. While none of the historical evidence presented by the defendant was related to his crime, his trial, or his sentencing, it's certainly true that in our nation, our history as a nation and a state, racial discrimination has all too often existed. And as the Supreme Court of North Carolina recently noted, in portions of society continues to be a pervasive evil. Dr. Sanders testified to some painful examples of that history and that evil. If the test under the RJA is whether racism has existed in our state, then there is no need for a hearing in this case or any other case. But that's not the question before this court. Rather, the question is whether this death sentence in this case was sought or obtained on the basis of race. The defendant has not shown that his sentence was sought or obtained on the basis of race. He has not supported that claim with his offer of statistical evidence, other expert testimony, or evidence from his case itself, or any historical evidence. In this case, an unarmed 18-year-old black high school student was shot through the chest by a defendant as he was fleeing for his life. In times past, this victim's life may not have been valued as it should have been. But in this trial, in Johnston County, in 2009, the jury determined that the taking of his life by the defendant was to be punished by the highest punishment under our law, a sentence of death. Defendant has not shown that that sentence should be vacated under the Racial Justice Act. Thank you.
Thank you. Any further from the state? Anything further from the state?
No, Your Honor, just to say that Ms. Doyle was here earlier, but had to leave for another meeting. She regrets that she couldn't be here, but that's why her presence is not here right now, Your Honor.
Thank you. All right, I'll hear the defendant in closing.
Thank you, Your Honor, and I promise to be
Well,
long-winded.
don't tell me what you've already told me.
I'm not going to tell you anything I've already told you.
Good.
Not much, anyway.
Sorry,
I want to just go through some of the arguments that were made by the state.
That's fine.
Whether discrimination has to be shown in the individual case. We know that's not true because the North Carolina legislature amended the Racial Justice Act a couple of years later to make that a requirement. And under the rules of statutory construction, we know that the legislature doesn't amend a statute unless it needs to. If that was always the requirement, they wouldn't have needed to make that change. The State versus Tucker, keep in mind, in Tucker, there was no evidentiary hearing. No one saw Greg Butler testify. They didn't have the prosecutorial affidavits. When the prosecutor says, I've never used gender and race in my decision-making, but yet we've got affidavits otherwise, that's the kind of stuff the Supreme Court didn't have in front of them. And
Let me ask you about Tucker.
Yes.
It appears to me that Tucker was decided on a limited factual basis, but the clear holding of Tucker is that the MSU study is not instructive. And what's to say that the court's not going to say, clearly we said the MSU study was not something that we were going to follow, and why, Mr. Defendant, are you repeatedly citing it and arguing with us about that ruling? Isn't that stare decisis as to the study?
I'm not arguing with the Supreme Court on its ruling as the MSU study relates to a requirement for an intentional showing by the defendant.
But do you think that the opinion in Tucker drills down to the nuance that you want them to? Or it seems to me pretty clear that Justice Berger said, we're not listening to the MSU study.
And those statements were made with no evidence.
Well, but I mean, my question to you is not whether they were correct or not.
No, that's not what
My question to you is, how do you get around citing to me, and if I were to say, well, yeah, I kind of think you do, and the study does it, how do we get around, if I had to go that way, the holding in Tucker when they're going to say, well, we're not going to listen to that, we told you Tucker wasn't any good?
2 points. One, part of Justice Berger's opinion on the validity of the MSU study, he was quoting Prosecutor Greg Butler, who said in another case, State versus Richardson, that the MSU study was, I don't know the exact language, the worst thing he's ever seen, or garbage, or something like that. And that's quoted in the Tucker decision as if it's a fact. Now when we have Mr. Butler on the stand and I ask him, have you read the study? What he says is, I may have looked at it, but not really. So they're relying on information that's invalid. But to answer your question, you could rule in this case without any reliance whatsoever on the Michigan State study. The sentencing study is a standalone, has nothing to do with Michigan State. We followed exactly what the state said their interpretation of the statute was back in 2022, which is just, you look at the numbers and see if there's discrepancy. There's clearly a discrepancy, and that discrepancy is statistically significant. The court could rule on the jury sentencing claim and nothing else, and not have to reach the remainder of it. I know, I'm not naive, I know that's going to be a battle when we go up to the North Carolina Supreme Court, if we go there, but the fact of the matter is, all they had before them, and they did not have the study, they had an affidavit. Only the affidavit. The affidavits that were filed in 2010, in August of 2010, when all of these Racial Justice Act motions didn't have all of the information that we have now. For example, in this case, we have all of the jurors coded in Johnston County. That's something that they didn't have in Tucker. We have all the jurors coded in District 11. That's not something they had. The Supreme Court was not aware, for example, that the Michigan State University researchers did a shadow coding. That's a different analysis that took everything in the light most favorable to the state. All the prosecutorial affidavits took their exact reasons given and did the study. That's a separate study that they haven't considered. But even that, taking into account Batson excuses and everything else, it was still racially, the race was still a significant factor.
What, the evidence that you presented as to the ADA Butler's cases and strikes
Yes.
were presented during his testimony? Do you recall?
Yes. Well, let me back up. For the ones in the MSU study, they were put in through Barbara O'Brien.
Right. But they still are evidence of an assistant DA's actions in this court that you want me to consider even separate and apart from it being in the study. Is that right?
Yes. And we, to answer your question, the remaining cases, the other 4 cases, were put in through Ms. Kenny, just with documents showing the jurors' strikes and the race and everything.
So talk to me about those cases and that set of information.
Just that, all 8 or just the 4?
Well, the chart that compared the number of black versus white sentences and the amount sought, and then whatever other one you just mentioned.
The sentences or the jury selection? I'm sorry, Judge.
That would be the sentences,
The sentences,
yes, of black versus white
yes.
under Mr. Butler, that, and the results.
That's not in evidence.
I think it is.
We know that the 4 on the right that are in the Michigan State study, on that chart, the ones that have the worst differential, strike rate differential, those have the high, those are all black defendants. The ones on, we do know, it is in the record, I'm sorry. The ones
It's in the record.
on the left are white,
Right.
with the exception of Jones, because Jones was primarily who he does.
Well, talk to me about that for a second.
All of those are death cases, that's right.
Well, talk to me about that for a second, and what you think it shows.
I think it shows that you have a prosecutor with a mind to discriminate, and he does. I think it shows that when he has a black defendant, he is more likely to strike a black juror than when he has a white defendant. There are, of the 8 cases, most of them are not even a high odds ratio, but way to the right of that on that differential chart. And so the court could take the position that could draw an inference from that he did the same thing in this case. The strike rate ratio in Mr. Bacote's case was 3.5, which is consistent with the other cases, except for Isaiah Barden, which was 5.7. That was really off the charts.
Talk to me about what in the record talks about disparity in seeking the death penalty in a felony murder only fact pattern.
What's in the record?
Yes, sir.
What's in the record is Mr. Bacote is the only person on death row who is on death row solely where no other theory of murder was presented to the jury except felony murder.
But were there ever any statistics about, either in Johnston County or the district or the state, about felony murder being the basis for death penalty cases?
In Johnston County,
Well, that's one of the things I mentioned, but
we didn't segregate it by Johnston County, but we showed the picture of all the people on death row who are there solely because of felony murder. But all the other individuals had another theory of murder presented to the jury that was rejected. So Mr. Bacote stands alone in that fact.
all right, go ahead.
So, Tucker simply doesn't apply because it's dealing with a different standard. A study might not be relevant for an intentional standard, but that's not what we're talking about. We know statistics are relevant and admissible under the statute. The criticism of Barbara O'Brien, the South Carolina criticism, remember, the criticism was that she had not done an adjusted analysis, which is what she did here. The North Carolina was not a jury selection, a peremptory challenge study. It dealt with cause issues and was a different type of study. And I don't mean to make light of Judge Ridgway's findings, but it was not the same thing as here. The sentencing study, I've already said, we did exactly what the state suggested, and that was to look at the sentences. We compared white defendants who were tried capitally and black, and we're talking about the imposition, not the charging, the imposition of the death penalty, and that we know is disproportionately black, or 100% of the black jurors received the death penalty. Now, so a lot was said about the weight of the evidence. So here's what I do want to show. We put on as many converging areas of information as we possibly could. We had historical evidence, Summers with implicit bias, prosecutors' affidavits, prosecutor notes, the jury selection study, Dr. Smith, Dr. Mitra, the propensity score analysis, her opinion that the unmeasured confounder is unlikely. Robert Wan, remember the grad student who said that Dr. Lee's grad student said the E-value was high. And then the inventors of the E-value is that anything above a 2, unmeasured confounder is unlikely. And on the other side of the scale, the state presented Dr. Lee, who said that the unadjusted analysis was statistically significant, the propensity score was statistically significant, and this is important. Dr. Lee said it's highly possible that there may be an unmeasured confounder. And what she said, is that specifically, I asked her, she said highly possible, and another time she said highly plausible. And I asked her, is highly plausible different from probable? And she said, I don't know what I mean. In English, they're two different words. So the point of that is, I'm not sure the state even, this is the battleground, whether the E-value is sufficient to show there's no unmeasured confounder. I'm not sure that meets the admissibility standard because she's not opining that it's more likely than not. Because even she agrees the E-value is greater than 2. So when you look at, this is the totality of the evidence. 3 of the things presented by the state are, I submit, should come over on our side of the weighing system, because that is where the E-value greater than 2 and the other 2 analyses being statistically significant is in Bacote's favor. I mean, that is a truckload of bricks compared to a feather on their evidence. Dr. Lee's evidence, highly possible, that's not sufficient. So before I said,
If you think about that statement, the confounders we know are things that sometimes you don't think about, but they think about later. You know, they may affect, may not, and they're very. And so an undisclosed or accounted for confounder. Could be anything. That to me doesn't say a whole lot.
And you asked her that question.
I
You
did.
said, could a study ever be done?
Yeah.
And I can't remember what the response was, but I mean, you brought that up at the hearing. And I'm about finished, but
I'm okay. Just tell, I'm okay.
one thing I failed to mention at the beginning, if the court has questions, I always welcome questions because I want to walk away from here answering anything you had. And before I sit down, I want to thank you and Ms. Wellington. I know that this group has not been the easiest to deal with, and it was just been a lot of logistics, and I appreciate that.
Well, y'all are easy compared to medical malpractice lawyers,
I do civil work too, so I agree.
which I end up being asked to do a lot of, and I'm just before going off their lists. I'd rather do special projects like this than get involved in those things. But not saying that the 3 I got I won't finish, but well, thank you.
I am thankful the state acknowledged the history of racism in North Carolina. I disagree with the state in whether we have linked the history of Johnston County in North Carolina to meet our burden of proof. And I'm reminded that, we've been litigating this for 12 years. I'm reminded of Dr. Martin Luther King when he said the arc of the moral universe is long, but it bends toward justice. And what makes me think of that is that I don't necessarily disagree. I don't necessarily agree with Dr. King. I don't think it bends toward justice. I think it takes people to grab that arc and pull as hard as they can toward justice. It takes legislators in Raleigh with courage enough to pass a law to say we're not going to have racism in the implementation of our death penalty system in North Carolina. And we and all the lawyers who have represented Mr. Bacote have tried mightily to pull that arc toward justice and to hopefully this court will see that. But
It would be one thing if it was something you were just telling me I needed to consider, but it's in the statute.
What's in the statute?
The breadth of what I can consider.
Yeah.
And so that, is a open door almost.
It is. And the whole time we've been litigating this, we've been pulling one way on that arc and the state's pulled another way. And now the arc is in your hands. And on behalf of Mr. Bacote and all the lawyers representing Mr. Bacote, we ask the court to bend this case to justice and rule in our favor and give Mr. Bacote a life without parole sentence. Thank you.
Your Honor.
Thank you very much.
Can
You're
I
going to
just
ask me to do the opposite, right?
No, I'm not going to get into the whole, I have a very firm idea what justice is. I don't think it'll line up with what defense is saying, and that's fine. Justice in this case. But I would like to, can I have 2 minutes to respond to new things that you asked him about?
If they're actually new things, but
Well,
I don't think they are.
one argument he
You
made
covered
for the
them from
first
my
time.
standpoint.
He said, hey, you can look at strikes by the lead prosecutor in this case and take an inference he did it in this case. Well, first off, inference is not preponderance. Moreover, that ignores the rulings on strikes that already happened in this case. And that's just correct. Tucker happened before all the affidavits. But Richardson didn't. It was just a unanimous opinion on the Batson issues by the North Carolina Supreme Court. Justice Morgan authored it. And in the late 2023, same prosecutor, Batson challenges rejected. MSU was an issue there too, but I'll leave that interpretation to the court. And the other thing I just have to say is they're trying to say, we did what the state wanted at sentencing. That is not correct. The state did say that it's a statistical. You look at the death sentences imposed for capital offenses. We argued that in discovery. They opposed that. Your Honor ruled in their favor, perhaps in abundance of caution, to give them everything they could get there discovery-wise to make their case. Now they've changed and says it's just that. So in one way, we sort of are in agreement, except they're looking at this small little end piece instead of looking at the proper data set, which is all capital offenses. So yes, we might have some agreement on statistics, but not on what the data set is. And that's all I'll say, Your Honor. Thank you for your time.
All right, thank you all for all your hard work in this case. The court, of course, will take this matter under advisement and will issue a ruling as soon as the court is ready to issue a ruling. I have no idea when that will be. Anything else from anybody else?
No, sir. Other than we need a transcript, Your Honor. You want to submit a
Let a transcript be produced and distributed to the parties.